Transfer of Property Act 1882. Doctrine of Election. The doctrine of election has been laid down in section 35 of Transfer of Property Act. What is election in this context? It means choosing between the inconsistent or alternative or contradictory rights. There are two rights not same with each other and we have the option to choose only one. It involves three parties: the owner, the transferor and the transferee. We must think that generally the owner and the transferor are the same persons, but not in this case. Here in Doctrine of Election, the transferor is a different person, the owner is a different person. The transferor professes to transfer the property of the owner. That's why he is called the transferor. He is a different person from the owner. We'll be discussing about it in details while we discuss the ingredients of this doctrine. Ingredients. The first one is a person must profess a property, to transfer a property which is not his own. I'll repeat, which is not his own. For example, A is a person who professes to transfer the property which belongs to B. B is the owner of the property, but A professes to transfer it to another person, C, the transferee. So A is the transferor, B is the owner, C is the transferee. Second, in lieu of such transfer, the transferor confers some benefit upon the owner of the property. Now, why will B transfer his property? It cannot be for free. He must get some benefits. So that is the second ingredient. In lieu of such transfer, the transferor, that is A, confers some benefit upon the owner of the property, that is B. The transfer of the property, the third one, transfer of the property and conferring a benefit must form a part of same transaction. What is same transaction here? The transfer of the property must be for the benefit conferred. The benefit conferred must be for the transfer of the property. It must be interdependent with each other. They cannot be independent. Now, if these ingredients are satisfied, what next? Next is duty. The owner gets a duty. Duty to elect. Elect what? To confirm the transfer and accept the benefit. He will say, okay, I accept the benefit, I'll transfer the property. Or he will dissent from the transfer and reject the benefit. He will say, no, I will not give my property, I don't want your benefits, take it. So these are the two options from which he has to elect. Hence, this is doctrine of election. What is the manner of election? Manner of election may be either expressed or implied. He can simply say it or write it. Yes, I accept your offer, or no, I reject your offer, take back your benefits. What is implied? Implied manner of election. Implied election is when the owner of the property accepts the benefits so conferred upon him while he was aware of his duty to elect first, and he was having full knowledge of the circumstances of such transaction, hence the transfer and acceptance. Two conditions: he must be aware of his duty to elect. Second, he must have the knowledge of the transaction. In these two circumstances, if he accepts the benefit conferred upon him, he is implied to have accepted the offer of transfer. Next, there are two presumptions provided in this part. The presumptions regarding knowledge of transaction. It is presumed when the owner has enjoyed the benefits of the property, benefit conferred upon him for 2 years without any act of acceptance or refusal of benefits so conferred. He has been conferred with the benefits. he has started enjoying it. He has enjoyed it for 2 years. In such case, the knowledge of transfer is presumed to exist in the mind of the owner. However, this is a rebuttable presumption. The owner can rebut it if he proves that he was not having any knowledge. Second, where the owner of the property has exhausted the benefit or consumed the benefit in such a manner that the original position cannot be restored of the parties. For example, the transferor has conferred the benefit in the form of money. He has given some monetary benefits to the owner, like 5 lakhs or 10 lakhs for a land. And what the owner did is he expended all the money. He spent all the money and now he is not in a position to return any money to the transferor. So the situation is the original position cannot be restored. And in such case, the knowledge of transaction is presumed to exist. Furthermore, if the owner of the property doesn't take any step of acceptance or rejection of the offer for 1 year, after completion of 1 year, the transferor may ask the owner to make an election, may make a requisition. If after making some such requisition, he still doesn't act, he must wait for some reasonable time. If after such reasonable time still he doesn't make any election, it shall be deemed that the transfer is accepted. Rights of disappointed transferee. Now, who is a disappointed transferee? Where the owner of the property elects against the transfer and the transferee does not get any property. I'll repeat again. The owner of the property rejects the offer of transfer. He elects against the transfer. He gives away his benefits conferred. He doesn't give his property, and as a result, the transferee doesn't get any property. In such case, the transferee becomes a disappointed transferee as he might have raised some hope of getting the property. In such case, the transferee is given certain rights. What are those rights? When the transfer is gratuitous means without consideration, and the transferor dies or otherwise becomes incapable of making a fresh transfer. And when the transfer is with consideration, whether he is alive or dead at the time of election, in such case, the transferee shall get a reasonable compensation from the transferor or his representatives. I'll repeat again, I'll explain with an example. The transfer is gratuitous. The transfer is without any consideration. The transferor dies or becomes incapable. When the transfer is with consideration, it doesn't matter if the transferor is either alive or dead at the time of election. In such case, the transferee shall get a reasonable compensation from the transferor or his representatives. Exception. Exception to this provision, to this doctrine, is where a particular benefit is expressed to be conferred upon the owner in lieu of the property professed to be transferred by the transferor, and the owner elects against the transfer, the owner must relinquish that particular property, that particular benefit, not any other benefits. For example, the transferor gives possession of a land to B to transfer B's land to another person. I'll repeat. For transfer of B's land to another person, the transferor gives possession of another land to B, the owner. In such case, B is liable to return back the possession of the land to the transferor if he rejects the offer of transfer. But before making rejection, he keeps the possession of the land for some days, and while such possession he gets some usufructs out of it. In such case, as usufructs was not the particular benefit expressed to be conferred upon him, the particular benefit was possession, so he has to return the possession, not the usufructs out of it, that have arisen out of it. Case laws. Codrington versus Lindsay. It says that the doctrine of election is based on equitable principle. A person cannot be allowed to approve a part of instrument beneficial to him or reprove another part of instruction that is against him. No one can approve it or reprove it at the same time. Ramaya versus Mahalakshmi. The rule of election operates only when the transfer and the benefit forms a part of same transaction. They must be interdependent and inseparable. It doesn't apply when both are independent. So that's it for doctrine of election. Thank you.